with the benefits that one party is going to derive from its contract with another party, right? And for this cause of action to be available, you can't be party to the contract. So the Glider and Worlds of Warcraft case is a perfect example of that. Glider's out there, or it's MDY Entertainment was the company that had the Glider case, but they're out there saying, here's this software, go out, make a bundle on Worlds of Warcraft. So that's interfering with Worlds of Warcraft's enjoyment of its contract with all its subscribers or users. Here, punitive damages, since it's an intentional tort, the requirement for the tort is that you do it wrongfully, that you do it knowing that what you're doing is wrong and intending to cause this damage, intending to cause this interference. If you can show that, then the plaintiff can get punitive damages. And punitive damages usually bear some relation to the actual damages that are shown, but you can get some surprising and dismaying results when they're available. And also, like in the situation with copyright infringement, company executives are potentially personally liable in the event that they are instrumental in having their company commit an intentional tort. So it's a very, very serious matter. Talking about, you know how I started off this, how we lawyers like to go by analogy. Well, trespass to chattels, you know, nobody uses the word chattels anymore, but it is a concept, a word inherited from the English common law, which informs, except for Louisiana, I believe all the state law in this country, the common law, and it just means property. And these cases started arising in the early aughts, 2000, and maybe even the late 1990s, as people started doing spam and unleashing other types of bots. Basically, the tort, which is the elements of which are going to vary from state to state, usually requires some kind of interference with chattel, and the courts have been willing to define that as somebody's networks, somebody's servers, somebody's information systems, in an unauthorized manner or exceeding the scope of the permission. It might have been, some of it might have been permitted, but if you push the envelope beyond it, you're setting yourself up for that kind of tort. Typically they're going to require actual damages, by which I mean out-of-pocket damages. Either sales were disrupted or something, some money was misappropriated. But that tort is available. Most courts asked to apply that ancient cause of action to this modern-day situation have said yes, this is an appropriate way to look at it. And again, with other intentional torts, punitive damages are potentially available, and company executives are potentially on the hook personally. Another thing, and this is, I say it's a typical cause of action. It's a little bit of poetic license. There's not. I'm predicting here that as if we're going to get up to 600 billion for bots, right? Litigation typically follows and develops with the amount of commerce being done. To the extent that people are using bots in a malicious way, a reckless way, sharp elbows, they're on the books of the laws of most states are consumer protection, unfair trade practice laws. I mean, the titles of them vary from state to state, and they also vary in their coverage. Almost all of them protect consumers. So the proverbial little old lady that buys a used car, is going to be protected by this kind of statute. And these kinds of statutes typically go something like, it shall be a violation of this act being the New Jersey Consumer Protection Act or whatever, to engage in a, quote, deceptive or unfair trade practice, end quote, okay? And then later in the statute they define what that is. And they define it, as an act involving deception or less than fair dealing, or and it varies. It's all over the place in the 50 states. What you need to take note of is that they often provide for double and treble actual damages and recovery of attorney's fees. Sometimes like New Jersey, I have sued another business successfully on behalf of another business, so a B2B context, even though it was originally enacted as a consumer protection statute. Courts have construed that broadly enough to say businesses are on the hook for that. Pennsylvania, you can't get away with that. But a plaintiff, when I wear my plaintiff's lawyer's hat, there's no holds barred. So, you can assume that other plaintiff's lawyers anywhere will, if there's a way to shoehorn what happened into this kind of statute, they're going to do it. There is a federal statute called the Computer Fraud and Abuse Act. This dates to the mid-'80s. And in a broad fashion, it's been updated several times. But it broadly prohibits unauthorized access or use of computers or transmission of code that causes damage to the operation of the computers or other damage. If you can show damages in excess of $5,000, in most cases, you're going to have a civil cause of action. So let me take a step back. This statute appears in Title 18 of the U.S. Code, which is the criminal code. So this is a criminal statute, and it carries with it, violations of it carry with it the potential of criminal sanctions and fines and penalties, i.e. imprisonment. And especially if you're messing around with government computers and government networks. However, if you can show damages in excess of $5,000 in some cases, it grants to the aggrieved or the injured party out there a civil cause of action. And it is actual, compensatory damages. I mean, it does not have treble damages or anything like that. But what is attractive about it is it gives you a federal cause of action. So, some lawyers are more comfortable in federal court. So there you have a federal cause of action. You don't have to worry about the amount of controversy. Without a federal cause of action in the United States, you need to show $75,000 or more in controversy. And you have to show that the plaintiff and the defendant are from different states. All plaintiffs are from different states than all defendants. That's called the diversity requirement. So if you have a federal cause of action, you don't have to worry about that. It's like suing bringing a constitutional claim or something like that. There are a patchwork, too many to go into in detail, a patchwork of other state statutes that, that I would just basically categorize, most of them I would categorize as, just computer abuse or computer crime statutes. Some of them are criminal, some of them are only civil, some of them are both. And they tend to be very broad, not written very precisely, not written very well, but some enacted to deal with very specific situations, like there's a number of ticket sniping statutes, basically what you need, the conditions you need for the enactment of one of these laws is something getting to the attention of some state legislature, some TV coverage, and all of a sudden, we're off to the races, and we got a law passed against something, right? Not that I'm suggesting I agree with ticket sniping or saying that we shouldn't have laws against ticket sniping, but that's really what you have. And so those conditions arise in different circumstances in the 50 states. So that's why I say it's a patchwork. Now, a word about jurisdiction. And this applies, really, it's worth mentioning with respect to just generally. Jurisdiction is an interesting issue with all things involving the internet and the web, because you can have, sometimes it's not really clear which jurisdiction's law should apply, and which creates potential problems as a business owner. If you have an international, you've got a website, it's not, if you don't expressly decline business from people from certain regions of the world, you're pretty much just signing on to whatever, potentially, you have a plaintiff who may be from some country you've never heard of. And